Death penalty case. What will the next hearing actually decide? On September 10th in Utah, a campus event ended with a fatal rooftop shot. A 22-year-old suspect was arrested after a multi-hour manhunt and is charged with aggravated murder. Prosecutors have publicly said they intend to seek the death penalty. Allegations only until a verdict. This is educational, not legal advice. Here's the clean roadmap before that next court date. First, confirm capital qualified defense counsel. Second, lock a discovery schedule for thousands of pages and digital files. Third, watch the clock on the formal death notice that turns this into a capital case. Utah law matters here. Aggravated murder becomes a capital felony only if prosecutors file a written notice within a defined window after arraignment. If they do, a death sentence is legally available. If they don't, the charge remains a non-capital first-degree felony with life-term punishments. That filing window is the first major gate. What about the evidence we know so far? Investigators say digital messages and physical items tie the suspect to planning and the scene. A surveillance clip from the day after the shooting shows a calm gas station stop during the manhunt. The defense has flagged the volume of discovery and asked for more time to review it. Volume isn't guilt, but it often drives the schedule. Now, what can actually shift at the next hearing? 3 levers matter most. Counsel qualifications in a capital case. Discovery, timing, and access, including protective orders for sensitive files. And any on-record discussion of aggravating factors the state may rely on. Aggravators are the why death category. States list them in statute. Things like premeditation, risk to bystanders, or killing to influence government activity. The list is finite, and the state must prove at least one beyond a reasonable doubt to open the penalty door. Mitigation pushes the other way. Mental health history, age, background, and anything that humanizes the defendant. That push-pull only happens if the case first clears the notice gate and a jury finds guilt. Expect classic capital case motions to suppress statements if the defense claims they were obtained improperly, to exclude certain images if prejudice outweighs probative value, to manage publicity or change venue if saturation threatens an impartial jury, to stagger discovery so experts can test ballistics, digital forensics, and timelines. Each motion is a lever that can narrow, delay, or redirect the trial. Let's talk timeline and jury, because those decide outcomes more often than speeches do. From arraignment, pre-trial litigation can stretch for months as both sides test evidence. A capital jury is selected in 2 steps, probing not just bias, but willingness to consider both life and death as lawful options. The guilt phase comes first, and only if the jury convicts does a penalty phase begin. In that second phase, jurors weigh aggravation against mitigation, not headlines against emotions. So what should you watch in the next public docket? 1. Confirmation that defense counsel meets capital case standards. 2. A discovery roadmap that shows when key videos, messages, and lab reports will be shared. 3. Explicit mention of the death notice clock and whether the state has or soon will file it. 4. Any preview, however small, of which aggravators the state believes apply. Those 4 items will tell you far more than social media noise. Here's the hinge I think matters most. Without a timely death notice, this remains non-capital and the penalty landscape changes overnight. With notice, every dispute over timeline, ballistics, and digital authenticity matters more, because the state must keep the proof record spotless. Capital juries scrutinize sloppy steps, and appellate courts do too. Context also matters, but carefully. Security decisions on the venue will get attention, and lawmakers will debate prevention going forward. Those debates may shape policies, not verdicts, because trials still turn on statutes, elements, and admissible evidence. Keep your eyes on the filings, not the hashtags. Bottom line, this case will turn on procedure and proof. Watch counsel qualifications, the discovery schedule, the death notice window, and any on-record list of aggravators. If the notice is filed, expect a bifurcated trial, with a penalty phase where mitigation evidence becomes central. If it isn't, expect a first-degree path with life-term outcomes still on the table. Your turn. What's your watch item number 1? Notice, timeline, or venue? Tell us in the comments, and subscribe for verified legal trackers as the case moves forward. Laws vary by state. This is educational, not legal advice.